Hello, I'm still Stephen Gold, but I was thinking of changing that to Steve Gold. If you want to change your name without really crying, have a look at my book, The Return of Breaking Law. Today I want to throw some light on the law or some law on the light.
Get on with it.
Fair enough. But if you will permit it, I'll start with a story. In 2018 in Leeds, a building was being redeveloped. And that redevelopment included adding 2 extra floors, a 6th and a 7th. My hero owned a building opposite, and through his windows facing the redevelopment, my hero had a right to, some say a right of, natural light. Well, that's a pretty valuable right, which hopefully, if you have a right like that, it'll give you bright rooms so that you can read my book, dance, gaze at the Picasso on the wall, all without floodlights, and not walk into a closed door. My hero got in touch with the redevelopers and tried to persuade them to change their plans to reduce what they intended so that his light wouldn't be reduced, but they didn't want to know. So what did he do? Nothing immediately, and the redevelopment went ahead. 7 stories later, a court case was started.
By whom?
The redevelopers. They applied for a declaration from the court that my hero had lost the chance of getting an injunction or compensation because he'd failed to start court proceedings before the redevelopment had started. But Mr. Hero cross-claimed. He asked for an injunction for the building to be altered so that his right to light would no longer be obstructed.
Oh, come off it. Not a hope in hell.
Well, I'm glad you're not my lawyer. My hero won. The court ordered the redevelopers to remove 1/3 of the top 2 stories. The judge decided that the degree of interference with the light entering his windows was so significant that granting him compensation wouldn't be enough. Where the redevelopers had gone wrong was in implementing their plans in the full knowledge that my hero's right to light was going to be affected and that he objected.
That's all very well, but all property owners have a right to light, don't they?
Pigs might fly. No, they don't, silly boy. It has to be earned. The most common way of acquiring the right is by having light come through the window or windows in question for
200 years?
Oh, close. 20. 20 years, and you can include in those 20 years time before you became the owner. The right might even have been clocked up by the previous owners so that you acquired the benefit of it when you purchased. But you need to show more than that the right exists before you can stop a development. You have to show that if it went ahead, the amount of natural light left would take away your comfortable use and enjoyment of the rooms. What you use the rooms for now and might be using them for in the future could be relevant. Also, the locality of the property may be taken into account in deciding the standard of light to be looked for. The obstruction must be more than trifling and amount to a legal nuisance. If a case went to court, you'd want an expert surveyor to back up your claim.
Can nothing prevent a right being acquired?
Spoil sport. It can. The title deeds for a start. A right can be excluded by the deeds, which often happens with residential property developments, so check your deeds before getting too lippy. And looking at the other side of the coin, if you might want to be the developer, perhaps in the future you want to extend your house at the rear or stick up a brick wall, and doing so could reduce next door's light, you could stop next door acquiring the right, if they don't already have it, by registering with a local authority what's called a light obstruction certificate. The 20 years have to be uninterrupted, you see, and the certificate has a legal effect of an interruption. Next door would have to start counting up the 20 years all over again. Very frustrating for them. More on how to get the certificate in my book.
It sounds as if this law could give a little person quite a lot of influence and power over a big developer.
Absolutely. I have a right to light. Your building would materially reduce the light. I'll take you to court if you proceed. Or, perhaps more interestingly, I have a price. I won't take you to court if you pay me compensation of...
Nice one. And there's a template letter to the developer in your book, isn't there?
I wondered why you had your head buried in my chapter 58. Light reading, you might say. Goodbye.